Okay. All right. Good afternoon, everyone. Thank you for joining us. We have a stellar panel for a very important topic today. We are panel 2A, Title VI, Civil Rights and Environmental Justice. I'm Leslie Fields. I'm the former National Director for Policy Advocacy and Legal at the Sierra Club, still based in Washington, D.C. I would like to introduce you all to our fantastic panel. Today, we'll be discussing Title VI Civil Rights in EJ. First, I want to bring to you Dina Tomei, or Patrice Sims, who is the Vice President of Litigation and Healthy Communities at Earth Justice. He's also a visiting professor at Harvard Law School and the co-founder and strategic advisor of People Over Plastics. Next, I'd like to bring to you his colleague, Dina Tomei, at Earth Justice. She's a senior associate attorney at Earth Justice in DC. And then we have Chandra Taylor Sawyer, who is senior attorney and leader of the Environmental Justice Initiative at the Southern Environmental Law Center in North Carolina. And she's also an adjunct law professor at the University of North Carolina School of Law. So welcome, panel. Thank you so much for making this time. And we are very, very, very lucky to have them. They are some of the best practitioners, environmental law, civil rights law, environmental justice we have in the country. So we are extremely fortunate. And look forward to a good discussion. We will leave room for questions at the end. But first, I just want to do a little table setting regarding, just have our panelists talk a little bit each about how they got engaged in EJ. What does it mean to you in context of your work? Just so you can learn a little bit about them and their story. And I think that will help level set our conversation. Dina, I'd love to start with you. If you could talk a little bit about your way you got to this work.
Absolutely. Hi everyone, I'm Dina, and my entry point into environmental justice work was other kinds of racial justice work. So before coming to Earth Justice, I worked on other racial justice issues like child welfare, disability, and immigration.
Great, thank you so much. Chandra Taylor Sawyer, and many folks know you, but could you please tell us a little bit more about yourself and how you got engaged in EJ, what it means to you?
So again, I'm Chandra Taylor Sawyer. I came to SELC 17 years ago, knowing that I wanted to work at the intersection of environmental law and social justice. So sometimes I work on the details of individual cases, but more often I'm working on the big picture of how a 200 plus person organization that spread over 9 offices and in 6 states can go about reaching the strategic plan goal of reducing the disproportionate burden of environmental harm on communities of color. And really, as a law firm, the work of achieving environmental justice is mainly like taking on these cases, taking on the most pressing cases for communities of color where we know that the most harm is being caused. But achieving environmental justice, I think, really is about doing this work in partnership with the most impacted communities. So making sure that we're doing the work to build authentic relationships with those who are most harmed by all of the contamination, the pollution, by suppression of political participation. So that's what brings me to the work and keeps me in the work.
Thank you so much. And Patrice, for you, what is EJ and its what does it mean to you and how you got engaged at Earth Justice? Quickly, we'd love to hear your backstory.
Sure. Thanks, Leslie. I started off as an environmental lawyer and spent about 7 years at EPA and between the Office of General Counsel and the Environmental Appeals Board. Left EPA back in 2005 and went to an environmental nonprofit and sort of started my career then in the advocacy space, and started that position about 2 weeks after Hurricane Katrina and Rita had hit the Gulf Coast, and was immediately introduced to that work. Spent time, much of that with you, Leslie, down in the Gulf in the months and year or so post Katrina, and that was really my first on the ground introduction to how important environmental justice was, and how incredibly neglected the environmental justice considerations in space were. And that was a pivotal point in my career, and it really focused me in a new way on thinking about taking the expertise that I developed over the course of the early part of my legal career on environmental laws and putting that to work for the benefit of advancing environmental justice as a significant piece of what I wanted to be doing. Soon after that, I left, realizing that I could. One of the problems was that there were so few people of color in these spaces, and there needed to be more, especially in the legal and policy conversations. And I left that organization and went to Howard University School of Law to teach environmental law and environmental justice, and help run the environmental law program there, really with the goal of changing the complexion of environmental advocacy to the extent, in the little way that I could in that role. And ever since then, I've been, a significant focus of my work, whether it's been in academia or with federal agencies in an appointment in the Obama administration, or with NGOs, and in my position now with Earth Justice. A big part of my focus has been on advancing environmental justice in every way that I could, and working to transform the practice in this space, whether it's in government or in the nonprofit space, in a way that's oriented around, more significantly around, advancing environmental justice.
Thank you so much for that. Great. So we're going to get into Title VI. What is Title VI? How does it work? And I want to just remind folks that Title VI of the Civil Rights Act of 1964 states that no person in the United States shall, on the grounds of race, color, or natural origin, be excluded from participation in and be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. The nexus being, the operative phrase being, federal financial assistance. And so there has been a lot of work done on Title VI over the years. There's also a robust group of academicians, civil rights lawyers, EJ lawyers, EJ activists, and a volunteer Title VI Alliance going on for over 10 years. But I wanted Patrice to elaborate more on the statute and what the implications are of it in regards to EJ and environmental law, to set that table.
Yeah, thanks, Leslie. I want to take the time to set the table a little bit, understanding that we may have folks in the audience who are really familiar with Title VI and folks who may not be that familiar with Title VI. A few really important things. I'll start with, and we'll come back to this, Title VI applies across the entirety of the federal government. So the limitations, the obligations that you described in the language of Title VI of the Civil Rights Act apply to any fund recipient, any recipient of federal funds, no matter where those funds come from. So it's not limited in any respect to environmental issues. Funding, as we all know, the government funds all kinds of activities, from farming to education to housing to transportation. And every one of those federal agencies has an obligation under the Civil Rights Act to ensure that its funds are not used in ways, as you described from the statute, that exclude from participation or deny the benefits of those programs in a discriminatory way. Title VI is really broad. It applies in a lot of different ways. It applies to a lot of different agencies, and that includes funds that are distributed by agencies like EPA in connection with environmental programs. And so it obligates EPA and other agencies to ensure that funds related to environmental protection are not used in ways that that create or exacerbate discrimination. There's some really there's some interesting things about how this has played out. We saw relatively early on, some crucial limitations to how Title VI operates. In a case called Sandoval, for example, the courts limited the availability of what we call private right of action, the availability of citizens or people, individuals, to bring a case against a fund recipient directly for alleged discrimination in violation of Title VI. And the court basically said, Title VI of the Civil Rights Act does not provide for this kind of private right of action, and therefore the only entity that can engage in that legal enforcement of Title VI is the federal agencies who have the duty to ensure that their fund recipients are not behaving improperly under the statute. What that means is it creates an interesting and in many ways problematic dynamic where when a community sees a violation of Title VI occurring, they cannot bring that claim directly to court. Attorneys cannot file an action in the federal courts. Instead, anyone identifying a violation of Title VI has to bring a petition to the federal agency, a complaint under Title VI to the federal agency, identifying the failure and asking the federal agency to take action to enforce Title VI. And so that's why when we think about the role of the lawyers, like those of us on the call today, in conjunction with Title VI, we're generally not talking about federal court cases. We're generally talking about complaints that are filed on behalf of communities or community members with federal agencies, asking the federal agencies to initiate an investigation and then take action to enforce Title VI. Each agency will be doing that under their regulations. So Title VI is a statutory requirement. It's very, very brief, as you read the entirety of the Title VI language, and each federal agency, including agencies like EPA, had to adopt regulations to implement, to describe how they're going to implement and adopt regulatory obligations and provisions to implement Title VI for their regulatory or for their programs and their fund recipients. And so each time we pursue a complaint under Title VI, whether it be with EPA or with HUD or with the Department of Transportation, we're doing so in accordance with the regulations that that agency has adopted to implement Title VI. And many of those are similar, but they have some differences as well. One of the things that is true about just about every agency's regulatory provisions under Title VI is that they prohibit, on the part of their fund recipients, both intentional discrimination and discriminatory impact, right? And this is really important and has been important over the years. And I expect that we'll talk a little bit more about that over the course of the conversation.
Thank you so much. That was great layout of the title of the entire, much of the entirety of Title VI and what the issues we're grappling with Title VI. So I wanted to get into how your organizations on behalf of communities are working on Title VI, using Title VI, and some of their success stories or some in the challenges, of course. And Chandra, could you please describe to us some of the work that SCLC has done on Title VI and some of the great work you've done on Title VI? And love to hear more about that.
Yeah, absolutely. So SCLC has been involved in several Title VI administrative complaints, starting with the 2014 concentrated animal feeding operation complaint against North Carolina Department of Environmental Quality. In that matter, I think I took at least a dozen declarations from Black neighbors to these industrial agriculture operations, listening, hearing directly from them about what it was like to experience the effect of living near these operations, what it smelled like, what their quality of life was like to be exposed to these really, really, smelly, polluting facilities. And to hear from them, I mean, I think it could have been 24 declarations, and to put those in a form that could be submitted with the complaint that was filed. And that complaint really had some significant helpful outcomes that are still being worked out to this day. SCLC is actually representing one of the original complainants in a lawsuit that is part of that outcome from that civil rights complaint from 2014. More recently, our Tennessee office filed a complaint on behalf of Memphis community against pollution regarding the policy and practices of the Tennessee Department of Environmental Control, and how they're assessing the demographics of their communities and considering environmental harm. We also have been involved in filing a Title VI administrative complaint in the state of North Carolina recently regarding biogas facilities, and in the state of Georgia on behalf of concerned citizens of Cook County. Just at the beginning of this year, filed a complaint regarding the failure of Georgia EPD to consider the demographics of communities when issuing air permits. That complaint is actually still pending under jurisdictional review. So in all of these matters, in partnership with community organizations or in partnership with nonprofits, have sought to rectify environmental harm for communities through this process. So of those complaints, one still is under jurisdictional review. 3 are still going through I'm sorry, I left out one. I also filed a complaint again on behalf of the concerned citizens of West Baden community in Stokes County, North Carolina, regarding a contaminated site that was contributing to contamination of surface water in an African-American community. And that was at a time when complaints were being dismissed if there was litigation that had been filed over a permit related to the same site. At this point, I think cases are being handled differently, but that complaint was dismissed without prejudice. So definitely this is a tool that our partner groups, our clients are interested in seeking the use of it to resolve their concerns, and one that we are getting additional experience with using to achieve environmental justice.
Thank you. That's really great It's been great work there. And I think also it bears mentioning that it's time consuming. And you mentioned the complaint that was filed, what, 2014? Some of these complaints are, it's been a real problem with being addressed. And it just shows the hard work of the communities involved, not giving up, and your hard work as well. So, Dina, can you go deeper into some of Earth Justice's work that you've been involved in, please?
Absolutely. So my work focuses on strengthening and ensuring enforcement of environmental laws and Title VI. And we really need both environmental laws and anti-discrimination laws to advance environmental justice. It's not an either or situation. So Title VI is just one of the tools we use, and it's somewhat of a new tool in our toolbox, so to speak, because EPA didn't enforce it for a very long time. So we're in a unique moment, I think, as advocates, where we have the ability to really hopefully shape precedent here, and to shape how Title VI is enforced. So I've worked on a couple of Title VI cases. One of them was a language access case in Texas, and that resulted in an agreement requiring the Texas Commission of Environmental Quality to provide certain language access services in certain permitting hearings. So that's kind of an example of a success story, I think. I've also filed two Title VI complaints on behalf of Concerned Citizens of St. John, which is a community group located in St. John the Baptist Parish, Louisiana, and also on behalf of the Sierra Club, alleging that two Louisiana state agencies violated Title VI. And this case is going to take a little longer to describe, and you'll see why. So the complainants alleged that the Louisiana Department of Environmental Quality and the Louisiana Department of Health violated Title VI by failing to protect Black residents of the parish from disproportionate toxic air pollution.
Dina? Oh dear. I think she just froze.
Looks like we may have momentarily lost Dina. I expect that we'll get her.
We just lost her. She'll be back.
Expect we'll get her back in a minute.
Okay.
Let me, while Dina's reconnecting, I think I can. I won't go into. I don't want to steal her thunder on the discussion about the Louisiana case, but I do want to give maybe a little bit broader view to your question about what Earth Justice is doing with respect to Title VI, and I'll let her jump into when she gets back on into that particular case. But we've been leaning in quite significantly to Title VI, as Dina was describing, as one of many tools that we use in working really closely with partners on the ground to address the disproportionate environmental burdens that they're facing. We view it, as Dina said, as a really important tool, but a tool that's insufficient on its own. And we view the environmental laws as tools that are really important and insufficient on their own. There are many things you can do through the environmental laws themselves, whether it's the Clean Air Act or Clean Water Act or Safe Drinking Water Act or other things, but they're very poor at addressing discrimination. They're very poor at addressing disproportionate impacts that are felt across very clear demographic dimensions. And we know that to be true from many decades of implementation of environmental laws. Our environmental laws, most of them have been around since around 1970. And they have done a dismal job in addressing very serious problems of disproportionate environmental burdens. And in fact, we've seen not just the creation of, but the worsening of many sacrifice zones around the country under those environmental statutes, and in nominal compliance with those environmental statutes. Among other things, really illustrates why strong Title VI implementation and enforcement is so important. And as we think about what Earthjustice has been doing, with myself and a group of folks within the organization have created what is effectively a Title VI working group. We've, over the course of 2022, for example, had at least 9 different Title VI claims either filed or in development and close to filing. And that number is always changing because the claims come, sometimes they reach termination and they go away. And so the number is always in flux. But what it means is that we're increasingly leaning into Title VI as an important tool in recognition of the fact that the environmental statutes themselves really don't and can't fully get at the discriminatory impacts.
Thank you, Patrice, for that. Dina, are you back? Your name is up.
While Dina's coming back, I think to illustrate what Patrice was referring to, like for each case, each administrative complaint that I mentioned, there was a companion lawsuit, or there was another lawsuit where we were, asserting environmental laws. And in order to, assert the discriminatory impact, where we were asserting like cumulative impacts of environmental harms, that's where the Title VI administrative complaint brought home that particular point. So, talking about the inadequacy of our environmental laws to actually address, cumulative impacts in some situations, really, I think, brings home like the fact that in these situations, there's every situation that I mentioned, there was, and in all of the last 4 cases, there was another lawsuit, at least, and there was an actual lawsuit in court that we filed. So I saw that Dina was back.
Yeah. Dina, can you hear us?
I can hear you. Can you hear me?
Yes, you're back.
Okay, I'm so sorry about that. I seem to be having internet issues. Where did I leave off? Like, what's the last thing you heard?
Well, you left off. You're just getting into the St. John's Parish.
Okay.
Yeah.
Great. Yeah. So basically, we brought these complaints on behalf of a community group, Concerned Citizens of St. John and Sierra Club, about 2 Louisiana state agencies' failure to protect them from disproportionate toxic air pollution. So EPA accepted the complaint and investigated it, and in October of 2022 issued a first ever letter of concern where it stated that the evidence strongly suggested discrimination. And so after that letter was concerned, we entered into negotiations to negotiate an informal resolution agreement, which would basically require the state agencies to comply with Title VI. And, the parties spent months negotiating that agreement, which is, there are versions of it that are public, drafts that would have included really important steps towards alleviating the harms that the community has been experiencing. But what happened is a few weeks before the agreement was set to be resolved and executed, the Louisiana Attorney General sued EPA and some other parties and alleged several different claims. So some of the claims had to do with these specific complaints. Some of the claims had to do with Title VI writ large. And one of the major claims that they brought was that they alleged that EPA's Title VI regulations were unlawful because Title VI doesn't actually prohibit disparate impact. That was their claim. And these complaints were brought under a disparate impact theory of discrimination. And so later, within about a month, Louisiana filed a motion for preliminary injunction asking for various forms of relief, including that the judge basically end the negotiation process. So about a week after Louisiana filed that motion, EPA announced that it was that it had administratively closed the 2 complaints that Concerned Citizens and Sierra Club had brought, and also a 3rd complaint related to similar issues in the air permitting process. And so, there's a lot to say on that. One thing I'll say is that EPA issued in this closure letter, it stated that the reason it had closed the cases was because the agency was doing enough to address the issues. And they named a couple of different sort of steps the agency is taking under environmental law to address the community's concerns. The problem is a lot of those remedies will take years to take effect, and also they don't specifically address the civil rights violations at issue in this complaint. And so that's sort of one of my points I want to make here, is that, like I said at the beginning, addressing environmental justice really requires enforcing both civil rights law and environmental law.
Right. That's right. One does not trump the other, right? And it's a very, very important point. Chandra, what are some of the implications of this situation that you see in your work and elsewhere in the country?
So definitely some of the things that we've been thinking about in the wake of the filing by the Louisiana Attorney General first has to do with the preliminary injunction. So what would it mean if the injunction was granted? Does the application of an injunction mean that there would no longer be an ability to file civil rights complaints with the external office, with EPA's external office of civil rights? Would pending administrative complaints, so we have several pending administrative complaints, would pending administrative complaints nationwide just be on hold because of an injunction in this matter? And that's serious. So, that's definitely justice delayed. Then in the future, the regulations themselves, the implementing regulations themselves that allow for disparate impact claims, those being in jeopardy is very, it's alarming, because proving intentional discrimination is a high hurdle, and to actually lose the ability to allege disparate impact claims or is something that would result in less relief for already overburdened Black communities, Latino communities, Indigenous communities. So, those are, just 2 examples of areas of concern. There's the spillover for agencies that are outside of the Environmental Protection Agency. Something that was raised earlier is that every federal agency has its own implementing regulations for the Civil Rights Act of 1964. So there are other agencies that also, like, Health and Human Services, Federal Highways, Transit, Housing, people's their inside environment is also important. So other ways that we might see environmental injustices taking place, other places that communities may have an avenue to file a civil rights complaint, those avenues would also be threatened, I think, down the line by a favorable decision for the AG. I think that's a matter of concern. In this case, what we've been watching is, the briefing here, and there was a very strong response from the government, stating that there's lack of subject matter jurisdiction, which we've been observing that, and I think it does show that at this point, by closing those 2 cases, that really at this point, what is the Louisiana Attorney General making an argument about, since those cases, there's like, what is the final decision that the Louisiana Attorney General is making any case argument about? So, those are some of the concerns that we are watching as practitioners on behalf of our clients. But that's the short list for now. But the briefing schedule is quite long. I think the hearing is in January. I think Dina knows best about that, but it's certainly a matter of concern.
Yes, this is very concerning. It's just relentless. So, Dina, getting back to you, as much as you can tell us about this, what's preventing, this is a very good example, what's preventing Title VI and from being enforced or being properly enforced or being stymied. How do we start to, if you could talk a little bit about what your thinking is, as much as you can, how we can use this situation to help strengthen Title VI, support these communities who are so overburdened to start. And then I want Patrice and Chandra to also follow up.
Yeah, so I think that this situation brings to light several sort of limits of the way that Title VI is currently working. Mm-hmm. And there's a fundamental disconnect between how Title VI should work and how it's currently working on the ground. So the way it's supposed to work is that state agencies, including, the two state agencies at issue in the Louisiana matters, have affirmative duties to comply with Title VI. And then EPA has an obligation to ensure compliance, and where that's lacking, to investigate and, remedy those violations. The reality is that basically the burden is put on communities to ensure compliance, even though they're the ones who are, the victims of discrimination, and the responsibility really is on the government. And so we're seeing that play out here. This community has been facing really, for much of the last decade, I don't know if this was cut out before, but has had the highest cancer risk from toxic air pollution in the country. And they brought the complaints in, over a year and a half ago, and the process has led to effectively no remedy for them. And so that's a major failure in the system. And I think that highlights another limitation in the system, which is somewhat of a self-inflicted one, which is, EPA's willingness to robustly enforce Title VI. EPA needs to commit the resources that it takes to implement it, and then they need to take the steps to actually enforce it. And here, what happened is the agency essentially caved to a lawsuit brought by the Louisiana AG. So I would say those are some major issues within how Title VI is working on the ground that this case really brings to light.
Mm-hmm. Yeah, it's very sobering. Patrice, kind of going up ahead of, this is also part and parcel of what you were saying much earlier in the beginning of the program about enforcement, and you had a inside peek of that when you were at the Department of Justice. Do you want to elaborate a little bit more?
Yeah, I think a couple of things here. As Dina observed, I think really importantly, in order for Title VI to live up to its potential, agencies like EPA have to really affirmatively be engaging in active implementation and enforcement, and not not effectively delegating those responsibilities to the very communities that are feeling the burden of these disproportionate environmental impacts. As Dina said, that takes resources. It also really significantly is going to take political leadership. And as many of the folks on this panel and probably many of the folks in the audience here know, there's some really good folks at EPA. There's some really good folks in the administration who care about this. But these are not things that are going to change within agencies like EPA without really strong leadership. These things don't change on their own. They're sometimes very difficult. They're sometimes even a lot of sort of institutional inertia that stands in the way of the kinds of changes that would be necessary. There's sometimes rebuilding that has to happen. And political leadership to make sure that these kinds of changes happen within the agencies that matter, like EPA and DOJ, is going to be really significant. I think we've seen some promising signs from the Biden administration in terms of some structural decisions. I think the creation, for example, of the Office of Environmental Justice and External Civil Rights at EPA, as designed to be an office that has its own assistant administrator, is a step in the right direction to create the kind of political decision-making structure within EPA that can begin to influence how the agency behaves around these kinds of issues. But this stuff doesn't happen easily, and I think there's going to be a moment where we all who care about this are going to have to really continue to keep the pressure on this administration to do what it needs to do to make sure that Title VI and civil rights mean something in the environmental context.
Thanks. I couldn't agree more. And I know folks on this call, folks in this session, some of these people have been out there for years and years and years on this. And Chandra, you know some of these people personally too. And that is. Do you have any other reactions about the overall situation?
I think one of the things that remains helpful, I still, we still have this tool that we can use, and communities that don't yet have representation, because, for all the criticism that lawyers receive, I think, there's still not enough of us to take on all of the ills that there are in the world. But Title VI complaints don't require a lawyer to file them. And people can be anonymous on the complaints. So those are things that still remain to be helpful, because there can be a lot of there can be retribution. It can be scary to file these complaints against those who receive federal funds, like sometimes federal aid recipients. They're not always state agencies. There can be private entities that receive federal funds that can be investigated by the federal, by whoever it is that is distributing the federal funds, so EPA or otherwise. So the fact that the filer, that the complainant can be anonymous, that a lawyer is actually not required, though, that the complaints don't have to be particularly detailed for the investigation to get started, does remain something that can be helpful for people who are viewing this, that may know of something that is very concerning and have not yet been able to get connected with legal resources, though. I do hope that there's a way to get connected to those legal resources, certainly in the Southeast, if there's something that's very pressing, that if there's a way to get in touch with SELC, that will get connected.
Mm-hmm. Yes, thank you for that. And there's still that opportunity. And also, people have used it as part of the organizing strategy. People have used it as part of the communication strategy. So, Dina, in terms of strengthening Title VI, where, after hearing, what Chandra was saying, where else can we utilize it?
Sure. Well, I think, as Chandra was saying, more community members can file more Title VI complaints, right? If they're seeing an issue in their community. There's also another option where communities can ask EPA to conduct affirmative compliance reviews of recipients of federal funds. So in evaluating sort of where to conduct those affirmative reviews, EPA does consider community input. And so that's another place where community members can get involved.
Thank you. That's a very, very good reminder. So for all of you, we're getting into rounding the turn here and on this discussion, and we'll open up for questions soon. But how there's been recent executive orders on environmental justice from the Biden administration, and what has been that impact of those recent executive orders on Title VI, and if any? Patrice, do you have any thoughts?
I'm happy to say a few things about this.
Okay.
So the Biden administration has taken a few steps earlier on, some steps to create some advisory bodies like the White House Environmental Justice Advisory Council, which significantly is involved in providing recommendations to the White House on environmental issues, including things like Title VI. We saw in April of last year or of this year, we saw the issuance of a new executive order directed at, in its words, revitalizing our nation's commitment to environmental justice. This is really kind of a follow-on to the 1994 Executive Order 12898. I think executive orders have inherent limitations, as certainly everyone on this panel knows, and probably most of the folks participating in this session know. Executive orders don't create new legal obligations or legal rights. Executive orders are not enforceable at law or in court. What they do is provide a signal from the head of the executive branch to executive branch agencies about the kinds of expectations that the executive branch leadership has for how agencies will function and behave. These can be really important signals, and they can create practices that are helpful to advance particular issue areas or initiatives. And I think some helpful things have come from or are embodied in the April 2023 Executive Order on Environmental Justice. Things like expressly expanding the agencies to which the Environmental Justice Order applies, to some degree clarifying some terms and more expressly discussing some of the things that are expected under the executive order, like consideration of cumulative impacts, specifically talking about the expectation of addressing environmental justice in NEPA analyses, incorporating some public accountability mechanisms that include publicly available environmental justice strategies by each covered agency, and self-assessments or progress reports to be published every couple of years. I think all of those things can be helpful. There is absolutely no magic bullet in executive orders generally, and certainly not in the executive orders that we've seen from this administration. They do signal, I think, a desire to move things in the right direction. And it will take a lot more leadership on these issues, and particularly on Title VI, to get us where we need to be.
Mm-hmm. Yeah, it's building up to, there needs to be the, advocacy and support and political will, but it's really terrible that the burden is still falling on these communities. Dina, do you, just wanted to let you finish up if you had any more thoughts on this. But also I wanted to ask, we are spending all of our time on Title VI, but if there's, remind folks are there other civil rights statutes? Have you had the occasion to utilize them in your work?
Yes, there are other civil rights statutes that EPA specifically is required to enforce. One of them, for example, is Section 504 of the Rehabilitation Act, and that prohibits recipients of federal funds from discriminating on the basis of disability, which is also an important part of environmental justice. So I would, I personally have not, brought claims under that section in the environmental context, but it is one example. Also, the Fair Housing Act of anti-discrimination laws that could be applied in the environmental context.
Right. Title VIII. Mm-hmm. That's right. Chandra, have you had occasion to use any other civil rights statutes?
So, no. However, I talk about, and my colleagues have worked directly on making sure that people's ability to vote is not suppressed. Political power is always going to be so significant in achieving environmental justice. So, and all the time across the country, what we see is that, Black communities are really being suppressed in their ability to express themselves politically, to vote in particular. So the political power of any community, the representation on planning boards, the ability to make decisions about zoning, in terms of that being a civil right, it's so significant. So I think in an environmental justice practice, looking at that is going to be integral. So, as we look at particular civil rights litigation across the country as environmental justice practitioners and advocates, thinking about voting rights, I think may become more of our practice down the line. Not so much right now, but down the line.
Mm-hmm. Thank you for bringing up this intersectionality. That is very important. And we've been we've done a lot of that when I was at the Sarah Club. Okay, so I want to give some time if you all had anything else you wanted to lift up before we get into questions. There's still some community folks who are probably watching this are involved with Justice 40. If there was any thoughts on Title VI and Justice 40, tease those out. But after that, I was going to open it up for questions or any closing thoughts, formal closing thoughts from you all.
I didn't want to forget to mention the National Environmental Policy Act and the revisions to it, just because for so long, that was the place where any mention of environmental justice was going to get the most coverage. That it was through the National Environmental Policy Act because of, just how prominent it is, those NEPA reviews. There is a public comment period that is happening today. Oral comments are today, and on the 21st, there's a written comment. Written comments are being accepted until September 29th. So going to the Council for Environmental Quality's website to find out how to submit those comments. But those revisions, I think, are significant to making sure that environmental justice considerations are, strengthened. There are some improvements definitely from the prior set of regulations. So I didn't want to neglect to make sure that got mentioned today.
Okay, so you suggest folks get on ceq.gov? Okay.
Yes.
Okay, and send in their comments.
Send in their comments. Yes, I just was noticing something going on with the screen over there.
Okay, happy to. Okay.
To weigh in on those regulations. And we actually, SELC, we have a environmental justice fact sheet. I have a short one, and I wish I could figure out a way to make that available on the EJ provisions.
Okay,
Perhaps
great.
I can figure out how to.
Dina, you all are nothing but chock-a-block in terms of information. Where can folks find more information to get involved or to be more informed?
Yeah, I mean, we just have tons of articles on our website. EPA also has a website on civil rights and Title VI and the other anti-discrimination laws that apply in this context. So I'd recommend reading those.
Okay, that's helpful. I think Patrice got scrambled a little bit, but that's okay.
Can you all hear me?
We can hear you.
Yes.
Okay, let me see if I can get my video to come back on.
All right.
It does not want to do that, but that's all right. I'm gonna just make one more observation. One thing I'd like to just remind folks is there's a lot happening as we've discussed in the context of our work with agencies and our expectations from this administration and political efforts on the executive side. I want us to not forget the legislative side as well. It sometimes feels hopeless to think about legislative changes fixing anything that really needs to be fixed. But I think it's worth noting that the Environmental Justice for All Act is really aimed at addressing some of these issues. It has been reintroduced, of course, this past session by Senators Booker, Grijalva, Lee, and Duckworth. It's worth people understanding what it is, taking a look at it. Again, it's the Environmental Justice for All Act and advocating for its passage. Ultimately, it would address some of the things that we've been talking about, including, for example, this question of whether discriminatory impact or is contemplated under Title VI, and whether there's a private right of action under Title VI, and it would address some other really important aspects of advancing environmental justice. And so, also encourage folks to think about and continue to support efforts for legislative changes.
Thanks for that great reminder. The EJ for All Act is still out. It's still live. It's still out there. It still needs to get pushed. Everyone can contact their representative and make sure that we try to get that legislation over the finish line. So I'm going to open it up for questions, and I think we have support in the come through the chat. I mean the comment section. I don't see any yet. So please, audience, please type in your good questions for this most excellent panel, and while you have the opportunity.
And while people are waiting on questions, I think another good place to talk with people is with, municipal resilience or sustainability directors, talking to municipalities about, how are they thinking about their Justice 40 obligations? We know that part of Justice 40 is that 40% of certain federal investments should flow to underserved, overburdened communities. So all across our nation, what are our leaders, municipal leaders, state leaders, how are they considering making sure, or even applying for these federal grants that can actually funnel to get to resources for the overburdened, underserved communities. So like right where people are, asking those questions, since that is, can be an effective way to reach a number of people to the ends of achieving environmental justice. I think that is a way to act toward the ends of achieving environmental justice.
Right. And there's also, I'm so glad you brought up the local municipalities, there's state opportunities of stakes. And it's a lot. It's really can be overwhelming. So it's very good that we have organizations such as Earth Justice, SCLC, some of the other organizations, and also the Deep South Center for Environmental Justice, Texas Southern University, just had their conference on Justice 40 recently, and I know a lot of information's out of there. And there's other groups that are also deeply involved. And to our audience, there's a lot of, just part of it wading through all the information, but there is help out there. And people who've been working on this a very long time. So I don't see any questions. Maybe we can keep talking about, in terms of, the challenges for this work. There are some structure barriers, and people have also seen, intimidation and cultural barriers. And I think that Dina, you mentioned you worked on the LEAP language access. Do you want to talk a bit more about that? Dina, are you there?
I'm here. Yep.
Yeah.
Sure, I can definitely speak to that. So
Okay.
basically, we were approached several years ago by community members who were concerned with the basically the quality
Mhm.
and the frequency of the provision of language access services in permitting hearings in Texas. And I think this case highlights a really important aspect of environmental justice and of Title VI, which is the importance of public participation. Right. So at these public hearings, community members are supposed to have the right, or they do have the right to provide comment on a specific permitting action. But what happens if you go to the hearing and you can't understand it? So it's really a no-brainer that community members need language access services to be able to exercise their right to public participation. And so that's what we were able to, to achieve through that case. So it resulted in an informal resolution agreement that required the Texas Commission on Environmental Quality to provide certain language access services.
Okay, that's great. Congratulations.
Thank you.
Yeah. So you see that, and there should be some more momentum behind that in other areas.
I think so. I think there is, and one thing I'll say is, this falls under sort of the national origin component of Title VI, is how it's been
Right.
currently understood. So it's definitely something that I think many communities across the country are dealing with, and that we're hoping more communities will advocate for the change that needs to happen.
Mhm. Okay, thank you for that. Well, I know there are great people watching, and I don't know why they're being so shy, but we're going to keep this conversation going for a while. So, this summer we're still seeing terrible heat. We're still seeing terrible climate disruption and trauma. And so, have you all in your work had an occasion to think about Title VI in terms of resilience and climate issues, climate justice issues? Mhm.
Well, I can speak a little bit to that.
Okay.
So one issue that we're seeing with climate change is, of course, the increase in frequency and intensity of natural disasters.
Mhm.
And those can cause what are called double disasters. So basically, when a natural disaster happens at around an industrial facility, which causes some kind of chemical leak to occur. And oftentimes those facilities are located in disproportionately Black and Brown communities. So that's not something I personally have addressed specifically through Title VI, but I do think that's an example of where that intersection occurs.
Yes, we're still in hurricane season. For that, for sure. And also, I mean, there's so many agencies that are involved. We focus a lot on EPA, but there's other agencies, and in terms of federal funding going toward communities after disasters, and how can we better monitor what happens in these places? And Patrice and I met doing after the aftermath of Hurricane Katrina, as you mentioned, and so it's very difficult, Patrice. And this hasn't really evolved that much since then, right?
Yeah, I think it's a really important space.
Yeah.
And we're in a moment where we're likely to continue to see more and more severe natural and unnatural disasters. You mentioned the sort of hurricane season and the impact of hurricanes, as we'll continue to see those continue to increase in frequency and severity, but we're also going to see other kinds of climate-related disasters happening with greater frequency and intensity. I mean, obviously, certainly for those of us who've been around for a while, we look at the fire seasons that we see across the United States now as something fundamentally different from the country that we lived in 25, 35 years ago, when this was just not something that was an issue, certainly not at this scale. We're likely to see flooding of various kinds. As we see really terrible decisions coming from the current Supreme Court. I'm thinking about, for example, the Sackett decision that withdrew protections for, really significantly withdrew protections for wetlands.
Right.
We're going to see more flooding. We're going to see more wetland destruction, which will have an impact on the ability of wetlands to play the important role that they play in preventing flooding and other kinds of disasters. And response to disaster will be really significant. And we, of course, have agencies like FEMA, I don't think, have done much examination of their Title VI obligations over time. And I expect that those are areas that will continue to be really important places for us all to be paying attention and doing advocacy.
Okay. All right. So in the final few minutes, if each of you could just offer some advice to the good folks watching this on how to better integrate Title VI on civil rights in their advocacy or their thinking, and how we can best support them.
So I'll start with a little follow-on from your last question that just had to do with acknowledging inland flooding and how many Black communities and communities of color are actually just a little bit inland, and not forgetting about those communities and what their needs are as we see the ravages of climate change. That's something that our policy professionals are looking at, and our other strategic initiative at SELC is our climate initiative. One thing that is very significant and that I'm thinking about all the time is just the necessity to talk to Black communities, because it's such a drive to do the most pressing cases, to do the important work. And it can take us away from talking to Black communities and doing the work in partnership with Black communities and getting the cultural competency, if we don't have it, to the cultural competency to do the work with Latino communities and Indigenous communities. Because when we don't actually have those conversations and work together, even if we look at a map and we know what the demographics of an area are, and we look at a toxic release inventory and we know what the harm is, and we set out to do work that we know will have great impact, we may be able to achieve environmental justice on paper. But if we haven't done it in partnership with the actual people who are most impacted, we have not done the most meaningful work. So I think as advocates, as people who are setting out to achieve, meaningful outcomes, actually talking to people who are most impacted is going to be significant and important. And it's easy to not talk to people who are not like you. So it's a hard thing to do in a lot of ways, but I think it's significant and that we have to keep trying.
Mm-hmm. Thank you for that admonition, Chandra. That was wonderful. Dina, do you have any advice for folks?
Sure. I mean, I think what Chandra said is really important. Any advocacy has to be totally oriented, I think, around what the community is asking for. I'd also say, and this is sort of related, I think it's just really important to work sort of across fields, across professions, and sort of worlds of knowledge. Like, I know, of course, we work with community members, we also work with scientists, and then we're attorneys. And I think that's really critical to address the issues on the ground as effectively as we can. And then I'd also say, today we've talked mostly about Title VI, but environmental justice is something that, ideally we'd be imbuing into everything we do. And so I'd also just encourage people to think about it as an issue that they can address in their work, regardless really of what law or what sort of specific issue they're working on within the environmental world. You can always be advancing environmental justice.
Yeah, thank you. Well said. Patrice, final thoughts and advice?
Just a couple of quick things. One, with a focus on Title VI in particular, we will keep doing this work. There is a robust conversation happening about Title VI pretty much all the time in the environmental context. And if folks are interested in getting connected to that conversation or exploring Title VI related opportunities or possibilities where they are or in connection with work that they're doing, they should connect to the discussion that's happening, and folks can reach out to members of this panel, and we can identify how to get connected to that conversation. And the other thing I would say is don't underestimate, like, Title VI is a great tool. It's a useful tool. We'll see where it goes in terms of how big of an impact it can have. But there's a lot that can happen at the local level, and we've seen some really tremendous things happening over the last couple of years. For example, state-level environmental statutes. There are some that have been adopted, as you all know, for example, in New Jersey, and they're a vehicle that others are exploring, and that folks should continue to explore if it's a politically possible route, either at the state level or even at the local level in some places. So, just an admonition to not forget about opportunities that can be non-federal and that can get at some of these same issues.
That's great. Well, we are on time, and I just want to express my gratitude for such a fantastic conversation today. I learned a lot. I hope you all in the audience learned a lot as well from these great practitioners and wonderful people who, and they are very accessible, please believe me. I hope everyone enjoyed the panel and will enjoy the rest of the conference. So thank you all so much. And thank you, University of Maryland. We will adjourn and enjoy the rest of the conference. Thank you so much. Take care.